Hello everyone, good morning. So, we are now coming down to chapter number 5, that is our administrative law. What is administrative law? I can simply say that administrative law is the law relating to administration. And for that we need to understand what exactly is the administration or who constitute the administration. We can say that administration is that part of the state which belongs to the executive body of state. We had classified our organs of state as your executive, legislature and judiciary. So, generally when it comes to the administrative functions of our country, it mostly vests with the executive branch of our state. Now, what you need to understand is that in our Constitution of India, the law does not specifically mention that the role of the judiciary is to be is only the function of interpreting laws, or that the role of the legislature is only to make laws and the role of the executive is only to implement laws. Even though they say that there is a separation of powers between the legislature, the judiciary and the executive, we can say that each body of state or each of these organs may end up performing each other's functions. Sometimes the legislature has judicial functions, sometimes the legislature performs executive functions. Now, the same way the judiciary may end up performing legislative functions as well as executive functions, and the same goes for the executive. The executive can perform judicial functions as well as perform legislative functions. So, when we say that these bodies of state are separated, but not separated to the extent where each one have only their own functions, but have certain interchangeability when it comes to functions, we are now looking at administrative law from the view of the executive. When we look at the executive, we can say that they are charged with the implementation of laws or the execution of laws. But it is not only the execution of laws that they do. Sometimes the executive can perform judicial functions, and sometimes the executive can perform legislative functions. Now, what is an example of the executive passing legislative functions? We can see that ordinances passed by the president and the governor can be the role of the executive doing legislative function. Because remember, the president of our country is the executive head of state, and his ability to pass laws is purely a legislative function. When I say that the executive can perform judicial functions, one example is where the President of India has the power to pardon a death sentence. This is one such example of the executive performing a judicial function, because it is the judiciary that passes a death sentence, and when the President of India pardons that death sentence, then he is essentially performing a judicial function. So, it is clearly understood over here that while the pardoning of death sentence and passing of ordinances are only one or few of the things that the executive can do, apart from that, we can say that the administrative law has multiple purposes within its ambit. First and foremost, it has the ability to make policies. Okay, it can administer the law and it can adjudicate the law. We can say that the act of administration is the act of its own executive function, whereas when we say that it adjudicates the law, it even has the power of a judicial function. It exercises legislative powers by issuing rules, bylaws and orders of a general nature. So, we can see that our administrative law is the law governing the powers, functions and responsibilities of the various organs of state. Okay. So, when we look at administrative law, we are not only looking at the law relating to the administration, but we are also looking at how the administrative affects the society through their legislative as well as judicial functions. If you have to understand what exactly administrative law is, administrative law does not have a specific source, in the sense that it is not an act passed by Parliament. We do not have an act known as the Administrative Act of 1950. No. Our administrative law comes from various sources or various places. But before we go into understanding where exactly the administrative law comes from, we first need to understand why we even need administrative law. Now, if you see, there are two aspects when we look at the need for administrative law, that is the traditional aspect and the modern aspect. What they are saying in the traditional aspect is that when there are three heads of government, that is your legislature, your executive and your judiciary, the traditional administration of justice is very expensive and lengthy. Therefore, there is a need for additional officials to empower the judiciary in speedier and less expensive modes of justice. So, what do we mean by this? Sometimes when we look at the judiciary, they have certain drawbacks when it comes to the judicial process. One, it is time consuming. Two, it is very procedural, and sometimes justice can be lost in light of procedure. And the third one is the number of judges are never sufficient. So, when we look at these aspects of what is happening with the judiciary, you have to understand that they have a very high caseload and a very few judges or lesser number of judges. So, it makes the whole procedure time consuming. Also, the CPC provides for a procedural aspect of the procedural manner in which you approach the court of law. And when you have to follow this procedure, it ends up becoming extremely time consuming. So, to counter this, what our governments and what our state has done is, they have brought in a remedy, in the sense that for the number of judges, they supplement them by additional officers of executive. So, instead of having only judicial members heading courts, they are saying that even members of the executive can be put in the capacity of a judge and to empower the judiciary in lesser and speedier modes of justice. We see this in respect of tribunals, wherein we have one technical member and one judicial member. So, when the executive is performing the functions of the judiciary as well as even the legislature, at that time we will need certain rules in place that help govern these officials to ensure that they are also following the letter of the law. If you have to look at the modern aspect of things, they are saying that the administrative functions are constantly increasing, because our government has started taking up more and more functions. The need for the law governing the administrative section of society becomes absolutely necessary. What does this mean? Today, in the current day world, we can say that our state has become a welfare state. And what do we mean by a welfare state? A welfare state is one where the government itself takes on the responsibilities of providing for its people. They provide not only in terms of food, shelter and clothing, but also provide, say, subsidies for obtaining materials, fuel, food, essential commodities. They also ensure that there is a subsidization for education, for jobs, for so many things. Now, when the government starts taking up more and more functions of state, we can say that our state becomes a welfare state. And when our country becomes a welfare state, it is the administrative section of society that is charged with the increased functions of government. So, when the functions of our executive is increasing, then we will need a higher number of officials in place for the same, and more importantly, we will need a law for governing them. And this is what the modern aspect is saying. If you see the traditional aspect, they are saying that the executive, when they are performing the functions of the legislature and the judiciary, that's when we will need administrative law. But then it also must be understood from the modern aspect that administrative law is, or at least the functions of the administrative are constantly increasing. So, when it's constantly increasing like this, there are more officials that are appointed for the purpose of administration. And it is when we are dealing with them, or when there should be rules in place to govern them, and that is only what we call as administrative law. So, let us look at the definitions of administrative law given by 3 different people. We have the definition given by Kenneth Culp Davis. The first one is Kenneth Culp Davis, Albert Van Dicey, as well as Ivor Jennings. Now, if you see the definition given by Ivor Jennings, he says that administrative law is the law relating to administration. It's a very simple definition, but it is not enough to distinguish between the real functions of the administration, or who is the administrative, or when does administrative law come into effect. However, it is true that administrative law is the law relating to the executive body or the administration. Our second definition comes from Kenneth Culp Davis. Kenneth Culp Davis goes on to say that any administrative agency which is basically just a government authority other than a court and other than a legislative body, which affects the rights of private parties either through adjudication or rule making. So, essentially what are they saying over here? He is excluding the legislature and he is excluding the judiciary from this definition. So, when he is excluding the legislature and judiciary, who is he including? He is including only the executive body, which is a government authority that is performing the functions of adjudication and rule making, that is performing the functions of the judiciary and the legislature. So, Kenneth Culp Davis's definition, essentially if you see, is not wide enough to say that it applies to all of the executive body of state, but rather he is saying that only when the executive is performing legislative or judicial functions, only then administrative law is required. And so, Kenneth Culp Davis' definition of administrative law is too narrow, or I won't say it is too narrow, actually it is the correct definition, but it specifies that the law is only required, administrative law is only required to come in when these actions are taking place, that is adjudication or rule making. Then if you see Albert Van Dicey's definition, he goes on to give a slightly or an extremely narrow definition. He says that administrative law covers all the rights and liabilities of private parties or individuals in their dealings with the state officials. So, in essence he is saying that, listen, I am not going to look at legislature, judiciary or whether it is performing these functions or not, but rather whenever the individual or the citizen or any other person is coming in contact with the state officials, Now, what do you mean by coming in contact with state officials? It's simple. If they have to get a permission, or they have to get a license, they have to revoke the license, or they have to get a certificate from the government, something, any activity where the individual is required to go to the state, that we'll call as our administrative law. So, if you think about it, this definition is extremely narrow because it doesn't cover so many other functions that the executive is doing. So, let us do a repeat of all the definitions under of administrative law. First and foremost, we have Ivor Jennings that says administrative law is the law relating to administration. Then we have a Kenneth Culp Davis who goes on to say that if a government authority other than the court or other than a legislative body affects the rights of private parties either through adjudication or rule making, then at that time administrative law comes into effect. Albert Van Dicey goes on to say that every time the rights and liabilities of private individuals are affected, when they are dealing with state officials or government officials, then we can say that it is administrative law comes into effect. So, these are the three definitions of administrative law under your chapter 5. Now, we will come down to now, Albert Van Dicey went on to propound another concept which is known as the rule of law. So, the rule of law principle is a principle which propounds or more specifically specifies that it is the government must follow the rule of law and not the rule of an individual. So, in the sense that we know that the government is also bound by the exact same laws that are applicable to everybody else in the country, and that the government must also follow a certain set of principles while enacting their work or doing their work. So, in the principle of rule of law, we see that there is a requirement of supremacy of law. That is, every law is supreme, it's absolute, and the supremacy of law should overtake concepts such as arbitrariness, abuse of power, or even the discretionary powers and the abuse of it. So, in a sense, they are saying that the law must be followed in its strict spirit, okay, and that is what we mean by supremacy of law, and the law is the supreme over here. Equality of law, that is, the law must be administered equally across the whole land, and whether it is administered by the courts or whether it is administered by the executive, it doesn't matter. The predominance of legal spirit. Now, legal spirit refers to all those judgments which uphold the legal spirit of every law that is passed, because some laws can be passed for the purpose of doing something or for a particular purpose, but it is the judiciary who ends up interpreting such a law and applying it on a fact to fact basis across our country. So, when the judiciary is interpreting the law, they will try to stick to the legal spirit of that law. But we have understood that even the administrative has certain judicial functions, that is, even they can adjudicate between parties or resolve disputes. So, when the administrative is doing it, even they must try to stick to the legal spirit of a law and not just apply the law in its bare form. How can we see the rule of law followed in India? We can see rule of law followed in India through our constitution as well as through our judicial precedents. So, if you see the constitution, we know that the fundamental rights and the DPSPs form some of the most important parts of our constitution. But apart from that, it is our preamble that consists of the rule of law, because it says that justice, equality, liberty and dignity should be given to all individuals, and in essence, while granting these aspects to individuals, we are also ensuring the rule of law in our country. Fundamental rights. Fundamental rights are such inherent rights or core rights to every single citizen in our country. So, when certain rights like this have been given to each and every individual, it ensures that certain actions of the state or the legislature cannot take away these rights from people. So, the fundamental rights are in essence there to ensure the welfare of our citizens. And lastly, we have our directive principles of state policy. So, they are saying that these are certain principles followed by the government of India to ensure smooth functioning of the country. So, we have studied about DPSPs in chapter number 2, and we know that they are a set of guidelines to be followed by our government when they are, for the better functioning of our country. If we have to look at certain judicial precedents, we actually have multiple judicial precedents on the matter of rule of law. But the one case law to note is the state of Madhya Pradesh versus Thakur Bharat Singh. In this, they are saying that our country is a federal structure and it is founded on the following principles: that the sovereignty of people with limited government authority. That means, while the people are the ones who govern the country, but since that is not possible to do so, we elect certain leaders who will in turn conduct the country or administer the country on our behalf. And so, what we do is we give them certain powers so as to ensure that there is a proper administration of work. So, we can say that the government must be conducted in accordance with the majority of the people, and this is what was held in the case of state of Madhya Pradesh versus Thakur Bharat Singh. The next one is the distribution of powers between the three organs of state, that is the legislature, executive and judiciary, are simply so that they act as some kind of a check, whether an indirect or direct check on each other. And more importantly, the whole point of rule of law is to prevent arbitrary executive actions. What do you mean by arbitrary? Arbitrary is unreasonable, or I will not write the word unfair, but rather an arbitrary is that which can be unreasonable or does not make any sense. So, if any government action is unreasonable when they are applying it to the persons, then the rule of law will come and strike down that unreasonable action or that arbitrary executive action. So, the state of Madhya Pradesh and Thakur Bharat Singh, they spoke about the sovereignty of the government authority is dependent on the will of the majority of people. The distribution of powers between legislature, executive and judiciary are so that they can act as a check and balance on each other, and the rule of law strikes down arbitrary executive actions. When we come down to the Keshavananda Bharati versus state of Kerala, we can say that this is one of our most landmark judgments, because a bench of 13 judges stated that rule of law is part of the basic structure of the constitution. And in chapter number 2, we had studied what exactly is the basic structure doctrine, and that the legislature or any organ of state is not allowed to amend the constitution so as to remove the basic structure of the constitution. So, in this they stated that the principle of rule of law is also a basic structure, and they went on to say that 1. An amendment must be confined to its scope to an alteration or an improvement of that which is already contained in the constitution. The amendment cannot change the basic structure, including granting of new powers to federal government, and an amendment cannot allow the state to remove any power already granted to it. So, these came in light of the multiple changes that happened in our country, certain amendments which were added to our constitution that gave excessive power to certain authorities over the other. So, in the Keshavananda Bharati versus state of Kerala, they predominantly held the principle of basic structure doctrine, and in light of what we are studying over here, they even held that rule of law is part of the basic structure of India. And then we finally come to the sources of administrative law before we proceed on to the rest of the chapter. So, let us try to understand what exactly are the sources of administrative law. Remember, I told you that administrative law does not have its own law, but rather it is obtained by reading certain other laws. And the first and foremost one is the Constitution of India 1950. The Constitution of India 1950 is one of the most primary sources of this law, because they are saying that the Indian Constitution, yes, let us read the example. Article 318 of the Constitution of India empowers the President and the Governor to make regulations with respect to the number of staff, to members or staff of the commissions and their condition for service. So, we can clearly say that there is some kind of authority being created, or a government authority, and this government authority is only known as a commission. And this commission is tasked with they're tasked with making regulations for this commission. So, in a way I can say that they are making a law over here. So, the Constitution of India itself provides for the creation of an authority, and more importantly makes regulations with respect to the number of staff in that authority. And who is the executive body over here? The President is the executive body of state, and the Governor is executive body of state. The second one is your acts and statutes, that is all of the various laws that are passed for the purpose of whether it is peace, order, economic and social growth, whether it is for defense or whether it is for providing benefits to people. There are certain level of grievance redressal mechanisms. That is, if persons are, or if the people are affected by the actions of the administrative, then the law itself provides for certain authorities to either pass laws or to even adjudicate on that matter. Now, one example we can see over here is with respect to your SEBI. SEBI is a body which has been empowered to make regulations under the SEBI Act, which is a rule making power. Then ordinances, administrative directions, notifications and circulars. So, what are they? These kind of ordinances is a type of temporary law. Administrative directions, notifications, circulars are issued by the executive to exercise various powers under the state. That means they have the authority to do so and they can do it. Example, the President passed the Criminal Law Amendment Ordinance 2013. And then finally, we have judicial decisions. We know that judicial decisions or the precedents are one of the primary sources of law. So, through their various decisions on the administrative, whether it is relating to liability of the government or whether the conduct of the government is correct or not, the judiciary has the power to interpret the law and ensure that the executive is not performing any arbitrary actions. And so, as we can see over here, Article 14 of the Article 141 of the Constitution states that all the decisions of the Supreme Court are binding on all courts in the territory of India.